Meeting to order. Meeting number 46 of the Standing Committee on Justice and Human Rights, pursuant to the order of reference of Tuesday, October the 16th, 2012. Bill C-37, an act to amend the Criminal Code, and we welcome the Honourable Rob Nicholson, the Minister of Justice and Attorney General of Canada, along with a colleague with him from the Department of Justice, Madam Morency. Minister, I'm sure that you're quite familiar with the rules and you have an opening address. Please feel free to begin with it.
By all means, it's about 60 minutes, Mr. Chair, so I hope that's okay with you. I'm pleased to appear before the committee today to speak about Bill C-37, Increasing Offenders' Accountability for Victims of Crime Act. Now, the government, as you know, has consistently made victims of crime a priority. And this bill represents our most recent legislative proposal to ensure that offenders are held accountable to the victims that they have harmed. I was very encouraged by the strong support shown for this bill by members at second reading. I think we can all agree that victims of crime deserve our full support, and I hope we can all continue to work together to ensure the swift passage of this bill. The bill proposes 3 changes to the victim surcharge provisions of the Criminal Code. The first change would ensure that the victim surcharge is imposed in all cases without exception by removing the option to waive the surcharge. Second, the offenders who are unable to pay the victim surcharge would be able to participate in the provincial territorial fine option programs to discharge the amount owing. Third, the amount of the victim surcharge that an offender must pay would double under this legislation. So all 3 proposed amendments serve the same purpose: to promote a sense of responsibility in offenders for their actions and to make offenders accountable to the victims whose lives they have affected. The changes which we are proposing in the legislation would address a number of issues with the operation of the victim surcharge that have been the subject of study and consultation over the last few years. First, and perhaps most importantly, it would ensure that the victim surcharge is applied to all offenders without exception. The original 1988 victim surcharge provision required the judge to order the surcharge. In 2000, the provision was amended so that the surcharge would be automatically imposed. The court could then waive the victim surcharge if the offender proved that its imposition would cause undue hardship to the offender or the offender's family. Despite this amendment, the surcharge is not applied in all cases. Research conducted by the Department of Justice in New Brunswick, published in 2006, shows that the surcharge was waived in 2/3 of the cases over a 5-year period of time. Remarkably, the surcharge was waived in 84% of cases involving summary conviction offenses and 91% of cases involving indictable offenses, where the offender received a sentence of imprisonment. In contrast, the surcharge was waived 25% of the cases where the offender was sentenced to pay a fine. Now, the research suggests that the noticeably higher waiver rate for offenders receiving custodial sentences is due to a blanket waiver policy for offenders who are sentenced to imprisonment, as opposed to proof of hardship to the offender or his or her family. Furthermore, in 99% of the cases where the surcharge was waived in New Brunswick, reasons for the waiver were not provided by the court, and no documentation was found showing that the offender had demonstrated that paying the victim's surcharge would cause undue hardship to the offender or his family. The research is particularly troubling as it shows that the current provisions are not operating as they were intended to. Waiver of the surcharge is not founded upon proof of hardship, but on presumptions about the offender's ability to pay. And we find this unacceptable. It's not acceptable for offenders, and it's certainly not acceptable for their victims. The victim surcharge is a part of the offender's sentence. We must be mindful of the underlying purpose of the victim surcharge: to hold offenders accountable to victims. This is entirely appropriate and is in keeping with the sentencing principles in the Criminal Code, which makes specific reference to promoting responsibility in offenders and making reparations for harm done to victims. For this reason, C-37 proposes to remove the waiver option in order to ensure that the victim surcharge is applied automatically as it was intended. Those offenders who are truly not able to pay the victim surcharge without incurring hardship would have the option of participating federal, provincial fine option programs to discharge the amount opening. This is the second change proposed by C-37. Fine option programs will allow offenders to satisfy the victim surcharge by earning credits for work they perform in programs operated by the provinces or territories. This is in line with the philosophy of the victim surcharge, which seeks to make offenders accountable to victims of crime. Currently, offenders who are unable to pay the surcharge are not required to take any additional steps to demonstrate their responsibility for their actions. Allowing offenders to discharge the victim surcharge by participating in fine option programs would ensure that all offenders are held accountable for their actions. Giving back to the community through such work would remind offenders of their responsibility to victims and to the greater community. Finally, the third change we are proposing in Bill C-37 would double the amount of the victim surcharge. This is an essential element of our package of amendments. The surcharge would be raised to 30% of any fine imposed, or where the punishment does not include a fine of $100 for a summary conviction offense and $200 for an indictable offense. This would be the first increase to the victim surcharge since the year 2000, when the provision was last amended. To ensure that offenders are accountable to victims for the harm they have done, the victim surcharge must be meaningful. Let us not forget that this is the primary purpose of the surcharge, to ensure that offenders receive a sentence that will promote responsibility for their actions. Because the victim surcharge is used to help fund services for victims, its payment allows offenders to make reparations to victims and the larger community. Questions have been raised about how the victim surcharge is used and how we can be certain that the amounts collected will truly benefit victims. To be clear, subsection 737 sub 7 of the Criminal Code directs that the victim surcharge will be used for assistance to victims of crime as directed by the province or territory where the surcharge is imposed. Each of the provinces and territories has established services for victims of crime and a dedicated fund for victim services in accordance with their provincial territorial victims legislation. Revenue from the victim surcharge is collected and remains in the dedicated victims fund of the province or territory where the surcharge was imposed. The provincial or territorial government decides how to use this revenue to fund victims' services in each province or territory, but revenue from the victim surcharge has consistently fallen short of expected amounts. We have worked with our provincial territorial colleagues to determine how best to address this issue, because we know they rely on the victim surcharge to assist in the funding crucial services for victims of crime. Many have said that they did not see any increase in revenue after the last amendments to the victim surcharge in the year 2000. This is why, under this bill, we are taking a two-pronged approach to reform. It would ensure that the victim surcharge is imposed in all cases without exception, and it would raise the amount that the offenders must pay. This approach, which was developed through research and consultation, is supported by the Federal Ombudsman for Victims of Crime, whom I believe you will hear from at this committee. This government takes its commitment to hold offenders accountable for their actions seriously. The amendments proposed will ensure all offenders are held accountable to victims either through the payment of the victim surcharge or through participation in community service. Raising the amount of the surcharge would ensure that offenders are paying a meaningful amount, which would have the added benefit of funding the services for victims of crime. We must continue our commitment to victims of crime, but we cannot do this alone. Meeting the needs of victims of crime is a responsibility that we share, of course, with the provinces and territories. In 2007, we established the Federal Victims Strategy to give victims a more effective voice in the criminal justice system. In 2011, we renewed the strategy with funding of $13 million per year, and in 2012, we allocated an additional $7 million over 5 years. Most of this funding goes directly into the Victims Fund, which provides grants and contributions to provinces, territories, and non-governmental organizations to develop or enhance victim services. And we will continue to work with our provincial territorial partners to ensure that they have the funding they need to offer much-needed services to victims of crime. I hope that we can also work together at the federal level to ensure that this bill receives the support it deserves to hold offenders accountable to victims of crime. Thank you very much.
Thank you, Minister. And now we begin the rounds. Madame Boivin.
Merci, Monsieur le Président. Merci, Monsieur le Ministre, d'être présent ici. Vous commencez à être partie des meubles à notre comité. On l'apprécie. C-37, on était effectivement bien heureux de pouvoir l'appuyer, d'une part parce que je pense qu'on est tous ici en cette salle d'accord à ce que les victimes soient indemnisées correctement. Il y a des besoins énormes à ce niveau-là. C-37 est peut-être un pas dans la direction, mais en même temps, il faut s'assurer qu'en adoptant C-37, on n'est pas en train de créer d'autres problématiques. Vous avez sûrement suivi les débats en deuxième lecture. Vous avez pu voir là où le bas blesse un petit peu pour l'opposition officielle concernant C-37, à savoir la perte de la discrétion du tribunal de pouvoir, dans des cas particuliers dont la preuve devait incomber à l'accusé, de démontrer qu'il était dans l'incapacité de payer. Alors, c'est certain qu'on a certaines interrogations par rapport à ça. Vous y avez touché un petit peu à travers les éléments de votre exposé, mais est-ce que le fait que ça semblait être presque un automatique, que ce ne l'était pas imposé, est-ce que vous avez pu en analyser la raison d'être? Est-ce que c'est, par exemple, parce qu'il y avait beaucoup de prévenus qui étaient sous le coup, par exemple, de l'aide juridique et que la Cour a peut-être, à tort ou à raison, conclu que s'il était sous le coup de l'aide juridique, il serait dans l'incapacité de payer? Est-ce que votre ministère ou vos services ont pu analyser le pourquoi? Est-ce que ça ne rentrait pas de la façon qu'on s'imaginait que c'était pour entrer au niveau de la suramende?
Well, you've raised some very good questions, Madame Boivin. Interestingly enough, the only province that actually publishes information with respect to this is the province of New Brunswick. And again, as I indicated to you, in the majority of the cases with respect to indictable and summary conviction offenses, it was waived, and again, very seldom do we ever get any reasons as to why this is the case. But I mean, with respect to judges imposing this, I mean, for the most part, I would imagine much of the funds will come from individuals who have received a fine. So in a sense, the judge decides what is the fine the individual is going to pay, and what we're saying is that there has to be a 30% surcharge on that for victims of crime. But ultimately, the appropriateness of the fine is determined by the judge, and indeed, with respect to summary and indictable offenses, again, the judges will decide or the juries, for that matter, will decide the guilt or innocence of the individual. And so this seems to be consistent with the penalties that we are imposing. And as I say, I believe it sends out the appropriate message that individuals must be accountable to victims, and that it's not just law-abiding Canadians who should pay for victim services. All those who create victims, they have a responsibility as well. And so I think this bill accomplishes that.
Thank you. I understand that point. That being said, would it be appropriate that a person who is in a total incapacity to pay the are your service and yourself as Minister of Justice, vous êtes prêt à voir, parce que je regarde la jurisprudence puis la cause de la Cour suprême dans l'arrêt R contre Wu, je ne sais pas si je le prononce correctement, où on disait clairement qu'une personne qui était dans une pauvreté extrême ne devrait pas être... est-ce que ça ne fera pas un peu une justice à deux vitesses, en ce sens, ceux qui, d'une part, font partie de provinces ou territoires qui ont le programme où ils peuvent ramasser les sous et ainsi de suite, et ceux qui ne l'ont pas, et d'autre part, ceux qui sont absolument dans l'incapacité, et on sait qu'ils vont être obligés soit de rester en prison ou faire de la prison pour équivaloir cette surprime, ce qui compense pas du tout, en tout cas à mon point de vue, à moins que le fait de faire de la prison compense d'une façon indirecte les victimes. Et je pense que là n'est pas la question, c'est pour ramasser des sous pour pouvoir verser les montants perdus par les victimes.
Yeah. Again, and you did touch on it, for those individuals who find themselves convicted of a crime in this country, there is the fine option program that's available in 7 of the provinces that allow people to find other ways of contributing and dealing with their inability to pay either the fine, I would take it, or the surcharge of the fine, or the surcharge that is on their criminal conviction for a summary or indictable offense. And indeed, in provinces where they do not or do not yet have one of these programs,
like
they
Ontario.
deal with it in a certain way. That's right. They either provide time for the individual here. They work with the individual. They send out certain notices to do this. And again, we're not talking about huge amounts. I mean, we're talking about $100 or $200 to people convicted of crime. And or again, it's up to the courts to decide if there is a fine to be imposed. Then the courts have all the information before them. But this will work. And again, for those particularly those provinces with fine option programs, it's another way for the individual to contribute through some type of community service and assistance to make a recompense in a small way to those people they've victimized and to the threats they've inflicted upon society.
Mr. Chair, and thank you, Minister and Ms. Morency, for being here with us today. I guess I've been wondering, Minister, I'd like you to address why, in your view, why this victim surcharge increase now? And I'm particularly wondering about the prevalence of the waiver, also consistency across the country in its application.
I suppose you could say it's consistently not been applied from the information that we have received. And again, much of it, of course, is anecdotal because much of this material is not available, with the one exception that I indicated. But I think there's a responsibility on legislators to revisit all aspects of these items. And the fact that it has not been increased or altered since the year 2000 means that it's due, if not overdue, to have a look at these issues. And so I think this is appropriate, and certainly it's consistent with our efforts to stand up and stand with victims of crime. And so I think it's a perfect fit on every level. And again, to make sure that this is now going to be a part of all sentences in Canada, I think is a step in the right direction. And again, changing it from the and it hasn't been changed since the year 2000. I think it's something, an idea whose time has come. Just so you know, to make sure that these things are administratively well put together, we didn't start indexing it. We didn't start indexing it to the cost of living or anything else, because we don't want a situation where one year they're collecting $100 and the next year it's $100 and $101.75 for instance. And so I think we're better off having a set amount like that, so that it is familiar to the court staff. It's easier to administer, but again, it's something that hasn't been updated in quite some time, and I think it was due.
Am I correct that these victims' funds that the money will go to, they're administered by the provinces and territories?
Yeah, they are. The examples of some of the programs that are administered, and they change as you can imagine, from province to provinces. This court, there are programs for court support for vulnerable individuals, victim notifications that are sent out from, and these are financed through funds collected through this, compensation under the Victims of Crime, referrals for counseling, victim assistance in preparing victim impact statements is another example. A number of jurisdictions where money collected from surcharges go to. So these are well administered, in my opinion, by our provincial and territorial partners. And again, it's another way of assisting them, and who, as you know, have for the most part the responsibility for the administration of justice in Canada. And so this is another way that we can help them.
Is this also, Minister, is this something that would have been discussed with your provincial and territorial counterparts?
Yes, it's actually a very good point. I do raise these matters on a continual basis with my provincial counterparts, and I was pleased of the encouragement and support that I have received over the years. These I get together with them, as you know, on an annual basis at least, and I'm in touch with them very often between meetings of federal, provincial, territorial meetings. But again, I believe this will be well received, and again, these go straight into provincial coffers, straight into the programs that they have to assist victims of crime. And so my prediction is that this will be very well received.
Thank you.
Still got a half a minute if you want it. If you don't want, that's fine.
That's fine.
Mr. Kotler?
Just right on that point, because during the consultations that I had when I was a Minister of Justice with our counterparts, provincial and territorial, at the time in 2005, the Attorney General of Manitoba recommended that the surcharge be increased at the time, as he put it, from 15% to 20%. Now, the increase here is to 30%. My question is the position of the Attorney General of Manitoba changed, or what was the response as a whole of the counterparts, provincial and territorial? Did they make that recommendation that it be raised, or did it come from a federal initiative with which they concurred, etc.?
Well, I can tell you the Attorney General of Manitoba in 2005 has changed.
Yeah, no, I know that.
Everyone across the country, and I'm getting together with them in another week or so, and I'll meet a number of new ones. And so, I mean, over the years, I've had representations, and again, you've been in this position as well, Mr. Kotler. You assemble these things. You hear as well from victims groups, law enforcement agencies, and so again, you come up with a program that you think that will work. And again, my prediction is, as I gave to Adam Finley, that this will be well received. And again, I suppose I'll give Dave Chomiak a call at some point in time and say, is this consistent with what he would have liked if he was still the Attorney General? But as I say, I'm sure it'll be well received.
Let me turn to the issue of the fine option program, because my understanding, I stand to be corrected, is that there is no fine option program at this point in either Ontario or Newfoundland and Labrador, and that in Manitoba and Alberta, for instance, the entry into the fine option program is only available at the point that an offender is admitted to jail, and that in Nova Scotia and New Brunswick, an offender may participate in a fine option program only after having paid the court costs and the surcharge portion of his or her fine. So by removing the undue hardship defense from Section 737 of the Code, provincial and territorial fine option programs may be the only avenues available for low-income Canadians to satisfy their surcharge obligations. But we have this variation here, as I mentioned, in the provinces, and the prospective impact with respect to low-income offenders based on their province or territory of residence. Have all these things been factored into your considerations in this regard?
Yeah, I think that's a good point. I remember having a look at this, and you quite correctly pointed out that, and it's to be expected that as each province develops or doesn't develop a program, there are considerable variations. And as you pointed out, in one of them, the fine option program does not apply to individuals who are given a fine. And again, it goes back to the question Madame Boivin directed to me about in terms of judicial discretion. Well, presumably the judge in making a fine is aware of the fact that he is or she is imposing a monetary amount on an individual who has been convicted of a crime, and that the surcharge, which is going to be 30%, is a part of that. So that being said, I mean, over the years, I've been assured by my provincial counterparts that these programs, they do work well, and they do accommodate individuals who would, for whatever reason, and it could be reasons of poverty, as you indicated, say that they can make their contribution back to society to begin that reconciliation process by helping out and doing some sort of community good work there. And again, that works. I mean, it still accomplishes the same thing, making individuals responsible for what it is they have done, and at the same time making a contribution. Again, I think most people would agree with me that these programs shouldn't be just funded by law-abiding Canadians, that the individuals who have been convicted. But as you say, there's a wide range across the country, and certainly when I get together with my provincial territorial counterparts in another week, I would be glad to have another discussion with them, and I'd be interested to know how this will work with respect to their fine option programs, and indeed if they're making any plans for changes.
Thank you, Minister, and Madame Morency for appearing. Minister, the law without passage, the law as it currently stands is the victim surcharge is required to be imposed in every case without the judge having to specifically order it. And of course, to balance that off, on the other hand, he has the discretion to waive the victim surcharge when it's perceived that it would cause undue hardship. I noted you were citing the numbers in New Brunswick, where the vast majority of the cases, no victim surcharge was imposed. On the other hand, New Brunswick is one of the provinces which actually has a fine option program, so that in itself is curious. In my mind, am I correct in saying that basically this is an attempt to basically balance the playing field in favor of the victims? Because look, there are options there to help them, to have the perpetrators of the crime pay for the cost of crime, and we know that the cost of crime, the last study was $99.6 billion. And surprisingly, 83% of it was borne by the victims. So in your mind, is this not an attempt to balance the playing field for the victims of crime?
We're always trying to do that, Monsieur Gauguin, and you made a very good point about the administration of this, that in the majority of the cases that I cited were individuals who were convicted of summary or indictable offenses. It was waived. There was no explanation, or to the extent that we can check there's no representations with respect to the individual's ability to pay. And so for the most part, I would guess that it's just either forgotten about, or it's just becomes routine not to either to impose it or indeed collect it. But that being said, to make this automatically a part of every sentence in Canada sends out a very clear message, and it's a good message, because victims who have find themselves caught up in this terrible situation in their lives, they want to know that their concerns are being heard, that their priorities are a priority of the criminal justice system, and this is not the whole show. I mean, this is just one component of that, but it's one more component to say to them that there are consequences to the individuals who has inflicted pain on them or their families, and it's another way for the individual to make recompense and to get back into contributing to society and say, okay, I've created these, I have these victims out there that I've inflicted this pain on, and in a way I'm helping to put something back into society here to try and to, make some amends on that. It's not very much in terms of monetary amounts, but again, it sends out that message that there are consequences. And again, for the individual who's paying these things, they'll say, well, okay, this is a start. The judge is imposing a penalty or an imprisonment or a fine on me, and I've got to start making my way back into society. I've got to, and so a victim surcharge is a reminder that these things are not just hurtful to the individual who is going to prison and he or she suffers and their family suffer. No, there are other people who suffer as a result of their actions, and this is a good reminder of that.
Thank you. Just quickly, Minister, Mr. Calder pointed out that 3 of the provinces don't have the fine option program: British Columbia, Ontario, and Newfoundland. Of course, we have a shared jurisdiction in the area of criminal law, and certainly the fine option program would fall under the administration of justice. Am I right in saying that obviously the federal government would cooperate with them in assisting them, not necessarily financially, but in helping them set up such systems if called upon? Because I think quite correctly, Bill C-37 now makes it mandatory to impose the fine, and it would be left to them if asked, to put in the system the fine option program.
Yeah, I mean, it's a good point. I mean, one of the things pointed out by Mr. Kotler in a review of what takes place across the provinces, there are, I'm not sure if any of them are identical. I mean, it seemed to me there are variations in all the provinces that have them, and that's appropriately so. I mean, the money is going to provincial projects within the province or territory, and so each one has to be tailored a little bit to meet the needs of the individual jurisdiction. But in terms of any advice or assistance we would give, we're always very pleased to do anything we can to assist, anything to help out victims. But ultimately, the decision will be made by each individual government in the provinces or territories. And again, even with those who don't have a fine option program, I mean, there are procedures that they take. I mean, things like you could have your driver's license suspended if you ignore a fine, for instance, that you received after you were convicted of a criminal offense. That's one of the options that they have. But again, if you're asking my preference, I certainly do like the idea that there's a fine option program, and I think most, as you know, most provinces and territories agree that that's a good way to handle it. But again, it's up to each individual jurisdiction.
Mr. Scott?
Thank you, Mr. Chair, and thank you, Minister, for joining us. I just wanted to continue discussing a little bit the fine option programs, whether or not available, or whether they're the conditions within each province that make a surcharge not something that the program will cover. It seems like we have at least 5, if not 6 or 7 provinces where there may be a problematic relationship in terms of availability. So let's just say it's 5. And the question is that, therefore, for at least offenders in those provinces, the special form of relief of the fine option program won't be available. And I just wanted to know, Minister, whether you've thought or whether you've received advice and what that advice is on whether does this fall into the area of a differential application of the criminal law that's problematic enough that we really need to be looking at principles of fundamental justice under Section 7 of the Charter as in play here, simply because the relief component, the law is holding something out, but it's actually not available to everybody in the country, but we have a nationally applicable body of law. Is there any issue there that you guys have crunched through to say, well, Section 7 is not a problem, or?
Well, when we look at all aspects of the federal jurisdiction and all the constitutional elements that go into this, but with respect to the Constitution of this country, it's very clear that it's the federal government that imposes the penalty with respect to violations of the criminal code. That being said, I wouldn't agree that in 5 provinces there's no. My understanding is, and my research in it, there are 7 provinces that have a fine option program. But again, as Mr. Kotler pointed out, there are variations between each provinces. But even those who do not have a fine option program, they have procedures in place in terms of allowing the individual, for instance, time to pay the fine, if it's a fine, or the surcharge, if it's a summary or indictable criminal conviction that results in imprisonment. But that being said, they have procedures in place, and again, it goes even to things like at some point in time you could have your driver's license suspended within a province that didn't have a fine option program if you continue to ignore the consequences of your criminal conviction. But in terms of the administration of it, the Constitution is very clear that where and how the individuals are housed and the administration of that is within provincial jurisdiction. And again, I think this is a fair application of that, and it's consistent with our constitutional responsibility to impose penalties under the criminal code.
Thank you for that. I think you may well be right that there's ultimately it's okay, but the reason I'm asking is that when we go back to a pretty landmark decision, the Morgenthaler case, the actual reason those provisions of the criminal code were struck down was that the criminal code was purporting to hold out a benefit of the criminal law, in fact a defense, that was differentially available across the country. And it was that differential availability, including how it interacted with provincial healthcare systems, that produced the problem with the fundamental principles of justice. And so this may not be nearly as consequential as what was being dealt with in that case, but it strikes me that there's some analogy there.
I think the exact opposite case could be made, that now there will be a consistency. And we won't have a situation where in certain jurisdictions the fine surcharge is routinely waived, for instance, or that it's applied in some cases in other jurisdictions. Now we can say with complete confidence this will apply right across this country, that it will be consistent with the provisions of the criminal code, and it applies to everyone. Again, how that the penalty is administered at that point is quite properly within the Constitution of this country, administered at the provincial or territorial level. But again, that's part of the Constitution. But they're all dealing with the same penalty, the penalty scheme, and so there's a consistency that's brought about by this that I think will be welcomed. Right,
and I would grant you that. I think that's absolutely right, that's certainly one effect. It's whether the rest of it would be a problem. Very quickly then, okay, the Wu case brought up by my colleague basically says genuine inability to pay is a defense to imprisonment for failure to pay a fine. And I'm just wondering, is it the Department of Justice position and your position that decision will cover a surcharge situation as well?
We've been very consistent that there will be a surcharge applied in all convictions across this country, and the where and the how of its administration is delegated, of course, to the provinces under either a fine option program or whatever program is put in place by the provinces. So it will be administered by the provinces, and I suppose, quite apart from the constitutional responsibility for the administration of justice, it makes sense since they're getting the money as well. The money is going into provincial funds for programs for victims, and so it makes sense on both of those levels.
Mr. Seaback.
Mr. Chair. Minister, I want to pick up a little bit on where we've been going with this discussion. We're talking a little bit about certainty on the imposition of a fine, and I found the information you provided in your statement to be quite interesting and worth repeating. 84% of the times in a summary conviction, the fine was not imposed, the surcharge was not imposed, and in 91% of the indictable cases. But I think for me, when I look at it as well, you mentioned that even when it was not imposed, there were no reasons suggested as for why. And if I take my look at the criminal code here, it's under section 737 sub 6, saying that when the court does waive, they have to give reasons. So would this be sort of part of the reason why you're looking at this legislation, because it seems to be a strange application of this section that's going on?
Well, I think one of the things that people have told me, those who work with me, is that there is no consistency in this particular area, and I don't know if there's anybody who would disagree with that. There is no consistency on that. And it seems to me that on the one level, there should be consistency with respect to the application of the penalty provisions of the criminal code. I think that stands on its own. But quite apart from that, the concept of reinforcing our support for victims of crime and victim services is something that sells itself and commends itself to me, and I'm sure to most people as well. It's a good idea to assist with programs that assist victims of crime in this country. So it seems to me it works on both levels, that we can and should have a consistency with respect to the penalties that are dealt with in the criminal code, and at the same time that whatever efforts that are made by us as parliamentarians to support victims of crime in this country and victim services is something that can and should be supported. So I think it works on both those levels. And so why did we do this? Well, you know of our continuing efforts with respect to the support for victims of crime in this country. This is a perfect fit, but you're quite correct. At the same time, I've heard about this now for quite some time, that there is a complete inconsistency of this. And as I pointed out to Ms. Finley, it's been since 2000 that even the level of the fines has been revisited. I mean, we can't go for another 100 years and leave it at $50, for a summary conviction offenses. I mean, you've got to have a look at it every so often and say, okay, is this keeping pace with the demands for victim services in this country? So they are not stuck at 2000 level of services and prices. And so again, the amount of money going to help victims has to be consistent with that as well.
Talking about support for victims, of course, it's something that we think is very important. I assume you've done some consultation. I know that the Federal Ombudsman for Victims of Crime, Sue O'Sullivan, has said that that we should double the victim surcharge and make it mandatory in all cases without exception. I take it that's someone that you've consulted with respect to this legislation, because it seems we've hit that nail bang on the head.
Well, thank you for raising that. And as was pointed out by Mr. Kotler, the former Attorney General of Manitoba had asked that we increase the victim surcharge, but certainly the Federal Ombudsman for Victims of Crime, as you just pointed out, she too has been calling for changes to the criminal code that are very similar to what you're looking at today. And so again, nothing's perfect, but I imagine she will be quite pleased when she gets the opportunity to comment on this.
Great. 1 minute. Wow, that's fantastic. And when you look at the application, and again, I want to go back to the consistency of the application of this. Do you see any circumstances where the new surcharge is not going to be able to be imposed?
One of the things that we've made very clear in the legislation is that now it is going to be imposed, that there's not a waiver of it at the time of sentencing. This is a part of the sentence. So if you get a fine, there is an automatic 30% increase for victim services, and we have doubled the victim surcharge for all summary and indictable offense convictions in this country. So it's going to be across the board. This is now going to be built into the criminal code when this bill is hopefully passed out of this committee and gets third reading and then proceeds to the Senate and royal assent. And so this will be a part of the laws of this country. And again, I think the majority of Canadians will welcome this, and I think this is a step in the right direction, as you can tell.
Thank you. Mr. Jacob.
Merci, Monsieur le Président. Merci, Monsieur le Ministre, d'être parmi nous. Donc, à votre avis, est-il possible, au terme du projet de loi C-37, qu'un contrevenant soit incarcéré parce qu'il est d'abord incapable de payer l'assuramende compensatoire et qu'il est également aussi incapable de s'en acquitter dans le cadre d'un programme de solution de rechange à l'amende? Dans l'affirmative, est-ce que cela pose problème, selon vous, Parce que vous avez dit tantôt, il y a quelques minutes, que ce serait appliqué de façon systématique.
It would not be applied. Yeah, it would be applied not just systematically but consistently across the country. Again, what you will find in each, in 7 of the 10 provinces, there's a fine option program for people who, for whatever reason, cannot or are unwilling to pay the fine or the surcharge. Again, where there is a no fine option program, you would have to look at each individual province or jurisdiction, how they treat these. What happens very often is that among them they will determine a payment plan for the individual, and if there are no payments, the individual, for instance, might find themselves with their license suspended. But again, it's up to each province and to the administration of that. But what we have and what we will have after this is passed is consistency with respect to the fine. You quite correctly pointed, if a fine is imposed on an individual, that would now and would have a victim surcharge. If the individual doesn't pay the fine that they have had imposed upon them, there is that possibility, of course, that they could end up in jail if you ignore the penalty they have been given. But generally, the experience has been that people who do avoid jail time by getting a fine generally pay the fine so they can avoid the jail time. I mean, that was many times part of either the plea arrangement or the penalty imposed by the judge. But again, what happens after that is administered by the provinces, and as I say, part of your look at this, you may find very interesting what a number of the provinces do in this area.
Parlons-en justement des provinces. Si les contrevenants condamnés en vertu du Code criminel ne peuvent participer dans ces programmes que dans certaines provinces, quelles mesures peut-on prendre pour que le projet de loi C-37 n'ait pas un impact disproportionné selon le lieu de résidence du contrevenant?
I've actually been quite impressed, Monsieur Jacob, over the years with respect to what provinces do in this. And we talk quite a bit, as you know, at the federal level, what we are doing for victims, but we're not the only ones. And I've been impressed by, non-governmental organizations, and groups, individuals, provinces, municipalities, what they are doing. And so that's one of the things that I have found over the years when I've traveled across this country. I've been quite impressed by the different services that are provided to victims. I've been of the opinion, and we've stated that very clearly, that we've got to do more. And, the Federal Ombudsman for Victims of Crime, I think, will say that. I mean, and so this is an ongoing project and commitment and priority of the government to continue to do this. But again, what happens at the provincial level, it's not all the same. I appreciate that. Nor is the fine option program the same, as we've already indicated. That being said, though, there are programs in place to assist victims. I don't know of any jurisdiction, quite frankly. I'll go out and say that. I don't know of any jurisdiction that doesn't have some type of programs that in one way or another assist victims. We can all argue and say they should be doing more, but again, I know of no jurisdiction in this country that doesn't in some way extend a hand to victims, and on that we are all agreed, and I'm always agreed with my provincial and territorial counterparts. To the extent that we make that a priority and continue to do more for victims, we're on the right track.
Est-ce qu'il me reste un peu de temps? OK. Donc, j'y vais vite. En cas d'augmentation importante du nombre de personnes qui demandent justement de participer au programme de solutions de rechange à l'amende, est-ce que l'infrastructure nécessaire pour traiter ces demandes, superviser ces travaux, comptabiliser les crédits acquis est en place actuellement ou sera en place bientôt?
Well, again, in terms of what will take place for the fine option program. If an individual gets a summary conviction offense and they've got a $100 surcharge, whether this will, hugely tax the fine option programs of our provinces, my guess is it probably won't. I think most people will come up with the $100 or the $200 if they have committed an indictable offense. As well, with the, you may have appeared in court yourself, Mr. Jacob, to know this, when individuals are given a fine, I mean, they usually scramble. They want to pay that fine because the fine is an alternative to incarceration, and for the most part, people would prefer to pay a fine, and this fine will include the victim surcharge, but that's what they would prefer. So I don't see any overwhelming of the fine option programs at the provincial level. And again, my belief is that my provincial and territorial counterparts will be pleased that there is now some consistency across the country, and every cent that goes from these surcharge goes into provincial and territorial funding programs, and so they'll be quite pleased.
Thank you. Mr. Elvis?
Merci. Merci, Monsieur le Ministre.
No. Thank you, Mr. Chair. Very happy to be here today. And Minister, thank you for you and your staff for visiting us today. I'd like to actually follow up with some of the things that Monsieur Jacob had brought up. Under the current version of Section 736 of the Code, offenders who are required to pay a fine may discharge the fine in whole or in part by earning credits for work performed under a program set up for that purpose. According to the current wording of Section 73710 of the Code, this fine option program may not be used for a victim surcharge. This bill, Bill C-37, will make it possible for offenders to also discharge the victim surcharge through the fine option program, where the program is available and the offender qualifies for it. How will the time required for the offender work through the fine option program? How will it be determined in order to equal the surcharge monetary penalty imposed?
Morency here to answer that one for you, Mr. Elvis.
If I understand the question correctly, I think the question is how would the amount work out into the amount of time taken to pay off the surcharge?
Yes.
So in each of the provinces, my understanding, the fine option program, basically they equate, it's often around a minimum wage to the number of hours required to pay off that surcharge.
Okay, so different provinces will have a different approach. Some might use a credit system, some might use a minimum wage. Is that correct?
That's my understanding, yes.
Okay. What kind of activities might be entailed, worked under this program?
Again, if you look at the different programs that exist in the provinces and territories, there are, as the Minister has said, variation between them. I think some of the common features are they tend to be for work in a, for example, work in a volunteer sector so that it doesn't detract from employment opportunities for others. And it's often in the, as I say, in the volunteer type of services in the community. Different provinces will have different types of services that can be identified, and once they get into the program, they'll be directed to that.
So if my understanding is correct, someone would either pay the fine, and of course that would support victims through this proposal, or they would then, work that time off through volunteer activities which would have benefit of the community in addition to that.
Exactly. I mean, that's a very good point. And while there's no money then going directly into victim services, it still sends the message out to the individual that there are some consequences for the activity that they've gotten themselves involved in, and they are contributing in some way to the society that ultimately has to pick up the tab for all this. And so I think it works on that level as well. So again, it's not directly going into the victims fund, but nonetheless, it sends the message home to that individual that they have committed a serious act for which they are having to do something to some sort of recompense, whether that be through community work, as Ms. Morency pointed out, or paying the fine. Either way, I think this is something that's constructive.
And so it's my understanding would be then that if they are doing something for the community, there's also pride that goes along with that. There's also the direction that goes under it, and at the same token, there's the value to society, as you said.
Yeah.
Just based on a more consistent approach to it, I'm sure the provinces would be happy to see that victim services would be funded with more consistency, would it not?
I think that is something that they certainly will welcome. And as I've pointed out, all the money from this goes to the provinces and the priorities that they set within the realm of helping victims. And so it will be, applauded on that level. And again, for those who like to see more money go into programs administered by the provinces, it's consistent on that level as well. They'll have more money to be able to put towards assisting victims. And so while everything we do doesn't get 100% support at every level, I'm quite confident that this will be well received by my provincial territorial counterparts. And again, we've had quite a few changes over the years in provincial attorneys general, but I think there's been a consistency there as well that they will like this. So I think it'll work.
Well, thank you, Minister. I think that pretty much answers all my questions. Thank you, Mr. Chair.
Mr. Cote.
Merci beaucoup, Monsieur le Président. Merci, Monsieur le ministre, d'être ici avec nous. Écoutez, j'écoutais attentivement ce que vous parliez de la situation au Nouveau-Brunswick. Je trouvais ça très intéressant, mais je voulais comprendre quand même, dans le cas des 99% des cas pour lesquels il n'y avait pas de motif justifiant le non-paiement de la suramende, est-ce que ces données-là vous permettaient d'établir s'il y avait une amende qui était imposée ou non, quelle était la proportion?
Yes, we can, alone of the different provinces, New Brunswick seems to have all the information on this that's available to us. And so, again, we've even given you a breakdown of when and where the surcharge that exists under the criminal code. And overwhelmingly, it's not applied for individuals convicted of an indictable offense, but for the most part, when a fine is imposed in the province of New Brunswick, I believe it's 75% of the time they do add on a surcharge. But again, in 25% of the cases, they do not even when a fine is being imposed. And so it varies between whether the individual is sentenced with a fine or imprisoned for an indictable offense. But it was very helpful to us, quite frankly, as to have a look at what happens statistically in the province of New Brunswick. But what happens there is backed up anecdotally as well from what I've been told across the country about the inconsistency of the victim surcharge. And so when we had to look, very carefully, obviously, at what took place in New Brunswick, and say, yeah, this is consistent with everything that we've heard across the country. And so that's going to change with this law.
Dites-moi, Monsieur le ministre, est-ce que le ministère de la Justice ou par d'autres sources, des sources provinciales par exemple, excusez-moi, des informations concernant la situation financière des personnes qui sont instruites en justice, qui font face à une condamnation?
Again, you'd have to ask each provincial, attorney general in terms of how much money. I mean, sometimes they have individuals who've stolen money. They end up in court, and so there are various levels of financial ability of individuals to pay, and this is why I believe a number or most provinces now are into the fine option program. So for individuals for whatever reasons cannot or do not want to pay a fine, will have that option.
Monsieur le ministre, au Comité des finances, c'est en 2011, la Société Elizabeth Fry du Canada estimait que 4 femmes sur 5 en prison sont incarcérées pour des crimes liés à la pauvreté, donc à leur incapacité à faire face aux défis que la vie nous impose à cause de leur situation financière. Est-ce que vous voulez commenter cette statistique?
Well, it may be that a judge in deciding as to what penalty to be imposed probably takes that into consideration among other things as to what is an appropriate sentence in each individual case. I mean, and so it varies with respect to the criminals. But I tell you what is consistent is what I hear from victims in this country here who want to be better informed as to what happens, to know what's taking place in the court system, to to make sure that they are either able to make sure they get their statement in or to attend hearings. And so there has been a great consistency among victims in this country as to what they believe the criminal justice should be doing to accommodate them. And certainly that's the bottom line here. The bottom line in this is to make sure there's a consistency of application of the criminal code, but it is to make sure that we send that message out to victims. We will do everything possible to look after their interests and to make sure that their concerns are heard in our criminal justice system.
Thank you. Il me reste encore un peu de temps. OK. Merci beaucoup, Monsieur le Président.
Thank you, Minister, for being here. We'll take a short break now until the Minister is able to leave and reconstitute our new panel. We'll call the meeting back to order. Welcome back, Ms. Montmorency and Ms. Arnott. And I understand that Madame Boyvan may have a question or two.
Quelques petites questions, peut-être plus techniques, juridiques, parce que lorsqu'on regarde C-37 et qu'on analyse Crowell, dans Crowell, la Cour a rejeté les arguments selon lesquels la suramende compensatoire devrait être considérée à juste titre comme une taxe provinciale. C'était le gros débat, parce que des fois, quand on regarde ces questions de suramende automatique, on est porté à penser que c'est une belle façon justement pour renflouer les coffres, même si l'objectif est louable au niveau d'aider les victimes. Alors, ça n'avait pas été retenu par la Cour parce que ça avait été vu plutôt comme un exercice du gouvernement fédéral au titre de sa compétence en matière criminelle, en vertu de l'article 91-27 de la loi. Et ça a été en partie rejeté parce que la Cour s'est fondée en partie sur la notion selon laquelle la suramende compensatoire infligée dans le cadre du processus de détermination de la peine constituait une expression de réprobation publique et sur le fait qu'elle n'était pas obligatoire. Mon inquiétude, c'est que maintenant, ça va être cross-border, tout le temps obligatoire. Est-ce qu'on ne risque pas de se retrouver dans le problème avant la décision dans Crowell, et est-ce qu'on risque pas de faire cet exercice-là pour rien que ce soit perçu comme une taxe déguisée, si on veut, pour ramasser des fonds, pour envoyer aux provinces, pour pouvoir se décharger de nos obligations envers les victimes? Ça serait ma première question à vous autres. Et je ne suis pas certaine que j'ai entendu la réponse claire du ministre là-dessus, mais est-ce que la décision dans Wu ne devrait pas continuer d'avoir application? Et sinon, est-ce qu'on ne pourrait pas parler d'une peine inusitée au sens de l'article 9 de la Charte, par exemple? Est-ce que vos services ont analysé tous ces volets-là par rapport à l'introduction de C-37?
Donc, si vous me permettez, je vais commencer avec la première partie de votre question. D'après nous, il ne s'agit pas de taxes. Dans le cadre de ce projet de loi, il faut quand même que les juges respectent les principes globaux de l'imposition de peine, c'est-à-dire le principe de la totalité, les principes de désuasion générale et spécifique. Donc, on ne le voit pas comme taxe. D'autant plus, je vous précise que dans plusieurs provinces, il y a l'option des programmes. Donc, ça fait en sorte qu'il y a une option autre que l'incarcération. Dans les provinces où il n'y a pas de tel programme, toutes les provinces et territoires ont d'autres mesures qui permettent soit services communautaires ou autres mesures pour un délinquant de satisfaire à l'assurement.
OK. Et continuer sur Wu, par exemple, sur la question de la décision de la Cour suprême dans Wu, est-ce que ça s'applique? D'après vous, ça ne s'applique pas, la décision dans Wu, avec l'amendement maintenant, avec C-37?
D'après nous, ça ne s'applique pas. Et je vous reviens sur le côté pratique. Dans la majorité des provinces, on a une possibilité de programmes de services communautaires, les programmes de fine option, si on peut le dire. Et dans les provinces où il n'y a pas de tel programme, il y a encore d'autres mesures. Donc, notre analyse, c'est qu'au niveau pratico-pratique, il n'y a pas de telle atteinte.
Donc, la personne qui serait dans un état d'incapacité financière grave, totale, et peut-être même d'incapacité mentale ou physique, d'aller faire un travail, est-ce que vous l'avez analysé dans cette optique-là?
Je peux vous donner des exemples pratiques.
Oui.
Donc, par exemple, à Terre-Neuve, il y a la possibilité d'une demande de, comment dirais-je, un plan de paiement. Donc, si le détenu ou la personne en question ne peut pas payer la suramende immédiatement, il peut payer par mesure, à fur et à mesure, pendant une telle période. Il y a d'autres provinces qui ont des programmes similaires. Donc, encore une fois, d'après nous, il y a la possibilité pratico-pratique de satisfaire à la suramende sans qu'on parle d'atteinte à l'article 7.
Fait que, pas pour être fatigante, mais même dans les cas, quand je parle d'incapacité financière grave, on parle de quelqu'un, par exemple, qui serait sur l'aide sociale, qui vit sur un budget extrêmement... Fait que même si vous leur donnez des paiements sur 25 ans, il y a peut-être une certaine incapacité aussi qui est liée à la personne même au niveau physique, au niveau mental, et on en a des cas. On va sûrement entendre des témoins qui vont venir nous parler de situations extrêmement pénibles qui existent avec les Premières Nations, par exemple, qui sont plusieurs à être malheureusement dans nos systèmes carcéraux. Alors, est-ce qu'on a vraiment analysé tous ces cas-là pour être bien certain qu'on ne crée pas en enlevant, parce qu'on réfère toujours au pouvoir discrétionnaire des tribunaux qui existaient avant, qui est peut-être mal appliqué, on pourrait en convenir parce qu'on ne sait plus pourquoi ils refusaient d'appliquer la suramende, mais on pourrait peut-être un petit peu plus circonscrire cette discrétion-là des juges plutôt que de l'enlever complètement. Est-ce que vous l'avez regardé, analysé dans ce sens-là?
On a consulté avec les provinces et territoires qui ont justement ce défi-là d'accuser devant les cours qu'ils n'ont pas de moyens. D'après les provinces et territoires, ils ont des programmes, ils ont des moyens d'absorber ou aussi de comprendre ce défi-là de personnes qui sont vraiment sans moyens. Je peux aussi vous préciser que plusieurs provinces souscrivent à un programme de l'Agence canadienne de revenus qui permet à des amendes d'être satisfaits par le retenu de, je perds mes mots là, de ton impôt là.
OK. Des prélèvements fiscaux.
Exactement.
OK.
Oui.
Merci.
There's been quite a lot of discussion that's focused on the fine options program, and of course we've learned that there are 3 provinces which don't have the fine options program, and clearly, the fine options program is the administration of justice, clearly a provincial competency, so it's not something that we can delve into. The opposition seems to be equating the absence of a fine option program to a form of undue hardship, yet you've explained to us that the provinces which don't have a fine option program proper have other means. We've talked about payment through Revenue Canada, suspension of license, the minister mentioned. That set aside, in the case of the victim surcharge, the fund goes to the province. A province who didn't have a fine option program, could they use the funds from the fine option program to set up a fine option program?
Each province and territory has legislation which specifies what the funds can be used for. And so for a number of provinces and territories, that is absolutely what they could use the funds for. The provinces and territories, so I think that's the short answer. All provinces and territories have legislation which specify what the revenue from the federal and provincial surcharge will be used for.
So within the scope of their constitutional authority, they would be able to set up the fine option program and use the funds coming from the surcharge. That's the short answer. I know we do a course of constitutional law, of course, but we're not here to do that. That's the short answer, correct?
Yes, sir.
Thank you. Thank you, Mr. Chair.
Butler?
Thank you, Mr. Chairman. I'd like to just pursue 2 issues that were brought up by my colleagues, both with respect to 2 Supreme Court judgments. One, the Wu case, and the second in the Crowell case. Now, the Supreme Court in R and Wu held that, and I quote, "It is irrational to imprison an offender who does not have the capacity to pay on the basis that imprisonment will force him or her to pay. For the impecunious offenders, imprisonment in default of payment of a fine is not an alternative punishment. He or she does not have any real choice in the matter." And they added, "At least this is the situation until fine option programs or related programs are in place." And I know you answered with regard to a question whether it was applicable to victim surcharges, that in fact the judgment was not applicable to victim surcharges. But my question is, would you agree that enforcement of non-payment by incarceration should be an available option only where a fine option program is available?
Mr. Kotler, I can speak to the victim surcharge, and in that case, I think as I've mentioned, there are a number of programs which would alleviate that problem of an absolute and utter inability to pay. I'm not able to speak to the more broader question of imposition of fines broadly.
Well, would the government support an amendment to the bill that would codify the Supreme Court's decision in Wu as applied to the enforcement of the victim surcharge?
I'm sorry, Mr. Kotler, I can't speak to that. What I can say is that we believe that the current existence of fine option programs and the other programs in provinces and territories that don't have a program would alleviate that problem of an offender having a complete and utter inability to pay.
Okay, because the court in the Wu case, clearly indicated that it was a prohibition of incarceration because of inability to pay, and that such a situation would obtain until fine option programs or related programs are in place. And I'm saying, in the event that they are not in place, would not the Wu decision, in fact, hold even victims' surcharges? And that is a situation we're confronted with.
I guess I would also point you, Mr. Kotler, to the coming into force provision of this bill, which provides that the coming into force can be set on a future day or days. We have an excellent relationship with the provinces and territories in terms of victims of crime, and can have conversations with them about their ability to administer and adapt to this amendment.
Okay, I just want to move quickly to the court in Aaron Crowell, which rejected the argument that the matter of raising that the victim surcharge being mandatory in all cases could be deemed by the courts to be a tax under provincial jurisdiction. Now, they rejected such an argument in part on the grounds that the victim surcharge imposed as part of the sentencing process was an expression, as they put it, of public reprobation, and the fact that it was not compulsory. The court also added that the surcharge's role as a deterrent is incidental to its fundraising purpose. So I have just two questions. One, in your opinion, is the surcharge's primary purpose to punish the offender or to raise funds? And two, does the proposed compulsory nature of the victim surcharge under the bill affect the Crowell analysis with respect to whether this is, in fact, a matter within provincial jurisdiction or within a matter of criminal law?
I think the first thing that I would say is that in regards to victims of crime, we are very conscious that this is an area of shared jurisdiction with the provinces and territories, and when the federal government is going to legislate in regards to victims of crime, we have to limit our legislation to that which is properly within federal competency. These amendments, we believe, are within the federal prerogative for criminal law as part of a sentence. We believe that they fit within the principles of sentencing, specific general deterrence, and also respect the principle of the totality of the sentence.
So I really only have one question, but depending on how you can help me, we might need to follow it up a bit. You said Wu doesn't apply, but as far as I understand, the principles of Wu are pretty clear, and there's two dimensions to saying it wouldn't apply. It wouldn't apply because it actually didn't deal with surcharges, and therefore, in some technical term, it doesn't apply. But if you look at the principles, it would have to apply. But what I heard from your answer was we don't expect it to be needed, because you gave examples of how even provinces without fine option programs can alleviate to the point that you wouldn't end up in the situation of needing the Wu principle. So can I just have some clarity on whether you just firmly believe it does not apply in that strong sense, or whether it does not apply only in the sense that we don't envisage it being needed, but the principles are still applicable to surcharges.
In our view, it's really the second aspect of what you've identified that is really the predominant factor. That when you look practically at a case, that the ability of all provinces and territories to find alternative means to obtain satisfaction of a sentence is what would stop that imposition of fundamental justice.
So, great, thank you. So that's really, for me, an important clarification. And I would only just say that for Mr. Gauguin drawing this out and your points, we would certainly benefit from knowing a bit more about the programs or the approaches in those provinces that don't have fine option programs, so we can be more comfortable understanding what is available to mean that we're worrying about something that needn't be worried about. And whether Department of Justice can help us or whether we should be asking the Library of Parliament to do a little research, I'm not sure. But to the extent you can help us, that would be great.
Okay, I'd be happy to do that. I also would suggest that it really is a matter of the provinces and territories. That I can relate to you what they've related to me, but they are obviously your best source. So some examples, and I can speak to Ontario. I think someone mentioned Ontario earlier. Yeah. So Ontario doesn't have a fine option program, using that name. Some of the options that they use, though, they do use license suspension, and those licenses can be not only driver's license, but they can be hunting license, fishing licenses. They'll use civil enforcement for very large amounts, so where there was a large fine and the surcharge was included in that amount, civil enforcement is an option. They'll use demand letters, which Crown Attorney offices will produce. They'll use writs. They'll use set-off of provincial or territorial payments. And they also are part of the federal set-off program, which, as I mentioned before, is a program from the Canada Revenue Agency.
Okay, well, thank you. That helps me a little bit. I'd have to be thinking more quickly on my feet than I'm capable of to know how much those examples apply to the kinds of folks who might be in the situation of being unable to, for example, a driver's license might not. But thank you.
Ms. Finley?
This is probably more of a comment than a question, but being a member of Parliament from British Columbia, and BC is one of the jurisdictions that does not have this program. And I can only say that I've seen, and from my experience, that in any situation really where someone needs to pay a fine or a court-imposed or hearing-imposed amount of money, if they do not have the ability to pay, say they're on social assistance or just out of work or whatever, there are mechanisms to go before what we call in BC a registrar and ask for time to pay, ask for some other way to deal with this. And even in what I would consider very reasonable or small fines, say like the $100 for a summary conviction, I have seen people being given many, many months at so much per month to come up with that, because I think it's recognized in our concurrent judicial systems that some people simply have a hard time even meeting those obligations. But I know they're given time to pay and with very, very modest amounts.
I'm sorry, go ahead.
Just to go back to some of the minister's remarks where he noted, for example, that the judges will have the discretion in the cases in terms of assessing what's the appropriate sentence to impose in that case on the offender before the court in all of the circumstances. So whether it's a period of imprisonment and or a fine, if the judge decides not to impose a fine, maybe there's another sentence. That's one way to address it directly. And in the instance where there isn't a fine, because the bill would require a flat amount to be paid, which is nominal, but as you say, could nonetheless have an impact for certain accused before the court. And those processes to deal with that, whether it's in a province that has a fine option program, which is the majority, or in the few that do not, but obviously, again, a recognition that it could have an impact, and there are measures available within those provinces to deal with it. So we've undertaken to see if we can provide some information that might be readily available to the department. It may be that the committee may wish to consider hearing from a witness from one of those provinces more directly to speak to that, but we'll see what we could provide.
I would just say to the committee that you have excellent analysts here, and the analysts will endeavor to bring back some information for you the next meeting or 2 meetings down the road on those things. And
provinces program, that'd be very helpful. Instead of having maybe all the and even I'd say even the provinces that have because it's from what we read already from their research, not all provinces have the same programs. So how does it work? I think it's important for us to be sure that it covers pretty much everything, and like you said, that you don't have any serious worries that the extreme cases don't fall into the cracks, and that a court would be forced to impose jail because the person has absolutely no other ways of fitting into any programs. That'd be helpful.
They'll endeavor to bring you back as much as they can, but recognizing that time is a little bit short, but I'm sure that they'll have excellent information. Okay, we still have a minute left from Ms. Finley. We have 1 short minute left from Ms. Finley, if you want to use that.
It won't take a minute. I'm more than curious to find out what all the programs do provincially as well. But bear in mind, we have no jurisdiction to impose upon them whatsoever as to what they do. I mean, if it's only for, intellectual curiosity, fine. I mean, they probably have the capability. But bear in mind, I mean, we have no sway with them. That's all.
Excellent analysts will bring it back for you. Mr. Cote.
Merci beaucoup, Monsieur le Président. Dans le fond, c'est suite, étant donné qu'on a des données quand même précises venant du Nouveau-Brunswick. Merci, Maître Arnott, Maître Morancy, d'être ici pour répondre à nos questions. Je n'ai pas pu m'empêcher de penser aux impacts financiers, à la capacité d'absorption dans le cas du mode facultatif de paiement d'une amende. Et, dans le fond, est-ce que le ministère ou les provinces ont pu vous donner une idée à quel point ça pouvait représenter quelque chose de relativement coûteux à absorber, ou si les capacités du terrain, en quelque sorte, étaient suffisantes pour faire face, justement, aux travaux là, pour compenser là, les crédits, des systèmes de crédit comme ça, parce que quand on voit, je pense que j'ai peut-être mal noté, on parle au Nouveau-Brunswick des 2/3 des cas ou des 3/4 des cas où il n'y a pas de suramende imposée. Ça va faire quand même une grande différence.
Pardonnez-moi si j'ai bien compris votre question.
Oui. Allez-y.
Vous demandez dans quelle mesure les provinces vont pouvoir absorber l'impact sur les programmes d'options de non-paiement?
Oui, que ce soit financier ou en capacité aussi des organismes sur le terrain, en capacité humaine de pouvoir absorber un nouvel afflux d'individus, de personnes qui ne pourraient pas payer l'amende, mais qui utiliseraient le mode facultatif de paiement.
Donc, ce qu'on a entendu depuis 2000 des provinces et territoires, c'est que les revenus anticipés de la suramende ne sont pas à la mesure ou satisfait pas aux prédictions. Donc, pour ces provinces et territoires, c'était en effet un recul qu'ils devaient faire parce qu'ils s'attendaient à un tel revenu. Ça n'a pas été atteint. Puis, selon nous, c'est suite au taux assez bas de l'imposition de la suramende. Ce n'était pas une conséquence d'un manque de collecte de la part des provinces et territoires.
Mais en gros, considérant que ça va être appliqué systématiquement, si le recours au mode facultatif de paiement est utilisé dans une grande ampleur, bien là, évidemment, ça va être simplement un crédit. Il n'y aura pas de compensation financière là non plus. Il y aura même des coûts qui vont être absorbés, soit par la juridiction provinciale ou par les organismes. En tout cas, il y aura à mettre en place des structures pour absorber ça. Alors, vous n'avez pas d'idée de ce que ça peut représenter?
J'ai pas de données spécifiques à vous donner malheureusement, mais comme j'ai précisé, on a quand même un groupe de travail avec nos homologues provinciaux et territoriaux et c'est le genre de choses dont on discute régulièrement.
Okay. Merci. Ça va.
J'avais quelques petites questions pointues, puisqu'il me reste pas beaucoup de temps. Donc, merci à nos invités d'être parmi nous. Donc, c'est où se situe la suramende compensatoire sur l'échelle des priorités en cas de faillite du contrevenant? Première question. Deuxième question, est-ce que le contrevenant qui ne s'est pas totalement acquitté d'une suramende compensatoire est considéré comme n'ayant pas complété sa peine? Est-ce que cela signifie qu'il demeure sous l'autorité du système correctionnel? Est-ce que cette situation peut durer longtemps, indéfiniment?
Donc, pour répondre à votre première question, malheureusement, je ne sais pas, mais on peut vous revenir avec la réponse dans le cas de faillite. Et pour votre deuxième question, mon homologue ici était une des principales sur le projet de loi C-10. Dans le C-10, on précisait que de telles mesures comme le paiement de la suramende ou autres obligations financières faisaient partie ou devaient faire partie du plan correctionnel d'un délinquant.
OK. Et puis, dernière petite question, j'ai quelques secondes encore. Si, lorsqu'un délinquant reçoit une peine pour des infractions multiples, est-ce qu'une suramende compensatoire est infligée pour chaque infraction visée?
Non. L'imposition de la suramende est faite au moment de l'imposition de la peine. Donc, pour prendre votre exemple, si quelqu'un est, s'il y a cinq motifs, la suramende va être imposée une fois si la peine est déterminée dans une seule audience.
OK. Parfait. Merci, Monsieur le Président. Merci aux témoins.
Thank you. I'd like to thank the officials for being here today. It's very informative, and I know the analysts will have some time to delve into those other questions. And just to the committee members, before you leave, you need to think of how we're going forward here. We're going to lose a day on November the 8th, I believe it is. And so when we, one day next week, we're going to have to take some time and make plans about where we're going and get some witness for the next sessions to the clerk so that he can have some time to get witnesses here after the break. Meeting adjourned.